Law Junkie Show. The jury now in deliberations in the Elizabeth Holmes trial. The Elizabeth Holmes trial where she was accused of wire fraud and conspiracy to commit wire fraud. She now awaits the jury's answer. But before the jury went back to make their decision, there was a lot of back and forth between the attorneys and the judges about their very specific instruction that they wanted the jury to take with them. What specifically happened there?
Well, I think it's important to note that the prosecution was interested in just the bare Ninth Circuit model jury instructions for wire fraud. And we've talked about this before, but I think it's worth discussing again. There are 4 elements in wire fraud. First, defendant knowingly participated in the scheme or plan to defraud. That's the basic part. The second is the statements made or facts omitted were material. In other words, they were big enough to have changed somebody's decision, meaning I'm an investor and I would not have invested had I known that Pfizer had not approved use of that logo in that slide. For example, the third element in wire fraud is that the defendant acted with the intent to defraud, the intent to deceive and cheat on a material piece of information. So this is really important that the mens rea was there for each element in the crime. And then fourth, that they used an interstate wire communication to carry out the attempt as an essential part of the scheme. But it's really, this all hinges on the mens rea, the intent. So meaning that she meant on that element to, with purpose, with knowledge, with possibly recklessness or negligence, although it doesn't say recklessness or negligence in this jury instruction, but that she meant to do this. She meant to leave out a major piece of information that altered whether or not these investors would have invested with Theranos or doctors would have used Theranos. So that was the prosecution said, hey, we just want the bare bones. The defense said, I don't just want the bare bones. I need you, Judge Davila, to instruct the jury that it should not be influenced by her, quote, profession, celebrity, or position in life or in the community. And the judge allowed the defense to have that, saying to the jury, no, you can't consider her profession, her celebrity, position in life, celebrity. This is really, this is the negotiation that happens between the prosecution and the defense regarding jury instructions. This is normal, by the way, that they would duke it out when there's a difference of opinion over what they want the jury to hear.
Before this trial even began, and in the beginning of the trial, there was a lot of talk that the defense was going to play heavily on this angle of abuse, that Elizabeth Holmes was controlled and abused by her former partner, Sunny Balwani. That didn't end up being the case. Why do you think they changed course?
I think that they left off the Balwani defense because, as we've discussed here on Law Junkie Show before, I didn't think it was a winning defense. I think that they needed to open up too many potentially damaging things for Elizabeth Holmes by saying, oh, Balwani controlled me, Balwani abused me, Balwani, whatever that defense was going to look like. They were going to have expert witnesses testifying on that regarding what the potential was. And by the way, that is not clear in terms of psychology, how much he could control her. So now you're going to have competing expert witnesses. Prosecution's going to bring their own, defense is going to have their own psychologist, and they're going to argue over that. And I just don't think it was ever a really good defense anyway, because you're essentially admitting, hey, I did it, but I did it because of what this guy did to me, meaning Sunny Balwani. And so the defense, I believe, smartly did not pursue that defense for Elizabeth Holmes and instead focused on this whole idea that, look, she was building a business. She was always focused on building the business. And look, mistakes get made, but she was never committing fraud in the process.
The defense also did not call John Carreyrou, the Wall Street Journal reporter, to the stand, the reporter who essentially caused Theranos to collapse. in many ways. What was the angle that they were going for in the first place by even considering calling him to the stand, having him on the witness list? And then why do you think they opted not to do that?
Well, I think that they chose not to go down the John Carreyrou path because Carreyrou has obviously very strong opinions. He has great protection under the First Amendment regarding his sources, because if I'm the defense and I'm putting John Carreyrou on the stand, I want to know why he chose to go after Theranos, what his motivation was, who might have directed him there in the first place, because that could indicate that there is something else going on. And absent getting to the bottom of who inspired John Carreyrou to modify his entire career from being a Wall Street Journal reporter to being focused on Elizabeth Holmes, podcasts, movies, there's this big Apple TV deal. I believe Jennifer Lawrence is maybe going to play Elizabeth Holmes. But I think that's what it is that there is just, again, you're not going to get a good, clean, clear answer from John Carreyrou. So what's the purpose of putting him up there? And he clearly doesn't think much of Elizabeth Holmes based on what he has written and what he's talked about on his podcast.
What does it take for there to be a hung jury in this case? And is it the same in all states?
A hung jury, in this case, this is a federal courtroom. So the case law that governs federal courts is the same, regardless of which state it is in. And here there is a Supreme Court case dating back to 1824 called United States versus Perez that allows there to be a hung jury and a retrial. But let's talk about what a hung jury is for a minute. That means we don't have unanimity of the jurors. In this case, we have 12 seated jurors. There needs to be, because it's a criminal case, there needs to be 12 votes for conviction, for there to be a conviction on any of the counts. Here, if one juror says, I absolutely can't find her guilty, I will not find her guilty, there's no argument you're going to make that ever is going to make me find her guilty, then we have what is called a hung jury. The judge does something called an Allen charge to the jury that says, nope, go back, work on this, you're going to have to give it another, as long as it's going to take, because we're not going to have a hung jury. And then what happens if there's a hung jury, it's a mistrial. And with a mistrial, the prosecution can choose or not to choose to go through all of this again. And the judge even has the right to say, I'm not even going to allow another trial. This is a mistrial with prejudice. And so, nope, this isn't even going to come back to my court. So a hung jury is a really big deal. Judges, and for that matter, really, counsel doesn't like to see hung juries either. We want a jury to be unanimous and clear in their decision of guilty or not guilty on each charge.
Can you take a guess as to what the prosecution and the judge would decide in that case if it were a hung jury or a mistrial?
Can I take a guess at what they would do? It's really hard to say that the prosecution here is going to retry this case, because this was many, many months in trial. This started like September 8th. It's December 20th. That's well over 3 months. That's 3.5 months. That is a huge amount of resources for the government to throw at this, on something that I believe is questionable, whether or not you can even convict Elizabeth Holmes on this. As I've said, I'm not sure that with the evidence as presented in court, which is all the jury can consider, when they look at that and compare it against the jury instructions in the law, which leads to the jury instructions. So there's the law, and then the judge frames the law in a way for the jury to understand how to apply the facts, the evidence as presented in court for them against the law. That's what jury instructions are. I actually have a hard time seeing that the government would prosecute her again. I have a hard time with that.
A reasonable prosecution would take the outcome of a mistrial or a hung jury as a sign that it's not a winning case. Don't keep at it.
I mean, I think that is would be a reasonable conclusion, unless they somehow come up with the missing database, for example. I mean, some other evidence that just we feel was missing. If there were some other large pieces of information that would have a material impact on the outcome of the trial, absent that, I don't know why they would retry it if there's a hung jury. I actually don't think there's going to be a hung jury in this case. I think that the jury is going to come back with a verdict on all counts.
And let's make some predictions. What do you think? What do you think the jury is going to say?
This is a hard one. So again, I didn't see all of the evidence as presented in court. All I've been able to do is read what all the different reporters have reported was said in court, which I've followed fairly closely. Excellent job. Again, Miles G. Cohen on Twitter has been an excellent source. I think it's a 70-30. 70% chance she is found not guilty, which again does not mean innocent, doesn't mean that she didn't do things wrong. It means that there wasn't enough evidence presented in court to find beyond a reasonable doubt that she committed wire fraud against investors. I think it's 70% chance she is found not guilty on that. And I think it's a 30% chance they find her guilty. And I think that there's even a smaller chance that the jury in their own way, because remember, they're human beings, even though they're not supposed to do these things, sometimes they do these types of things. I think it's quite possible that maybe they find her guilty on one count of conspiracy, for example, that there's just enough evidence that there was a conspiracy with Sunny Balwani to, whether it's defrauding doctors, patients, or investors, whatever that might be, that's maybe their little olive leaf of saying she's guilty of something, but we couldn't really find her guilty of everything.
And I'm assuming if she is found guilty, they would immediately appeal. And what would that look like?
Well, you have a certain amount of time to appeal in federal court, and you file a notice that you're going to file an appeal, and then you file the appeal. There are different types of appeals in this case, whether or not you thought that there was a problem with the actual trial itself versus appealing to the Ninth Circuit to say, look, there was a question of law that was improperly handled. That's usually what appeals are, is a question of law that you're asking the appeals court to say the district court judge was wrong about the law and it had a material impact that affected the outcome of the case. Meaning, if I'm the defense, the judge was wrong about granting something the prosecution wanted, and if they hadn't given that to the prosecution, then my client would have been found not guilty. Automatic appeal in a criminal case, you're just going to appeal. So if she is found guilty, they will appeal. Whether or not the Ninth Circuit takes it is a whole separate question.
Thank you for listening to Law Junkie Show. Please subscribe to us on YouTube and on Apple Podcasts or wherever you listen to podcasts. Follow us on social media. Visit us at lawjunkieshow.com, and you can send us a message at info@lawjunkieshow.com. See you next time.
Disclaimer. Law Junkie Show, including its guests and hosts, are not giving out legal advice, but discussing general legal issues. Law Junkie Show does not guarantee that the legal issues discussed are fully accurate, and it's not specific to whatever legal issues you may be experiencing. None of this advice is to be acted upon in your situation. Please seek legal advice from a licensed attorney in your jurisdiction for your individual legal matter.